Welcome everyone to a short webinar on jurisdiction and the Indian Child Welfare Act. My name is Jed Parr. I'm the Directing Attorney in California Indian Legal Services Sacramento office. Today we're going to be talking about how Icwa and a federal law known as PL 280, short for Public Law 280, combine to create the different jurisdictional possibilities that we have here in California when it comes to a child welfare case. We're going to be starting with a couple of basic definitions, jurisdiction and concurrent jurisdiction. We're going to go into a little bit of background on both the Icwa and PL 280. We're not going to go into either one of those in a great level of detail because that's way beyond the amount of time that we have available today. But we will cover it enough for you to understand how those two interact when it comes to jurisdiction. And after we talk about that interaction and the specific provisions of the Icwa and PL 280, we will then be talking about what it actually looks like in practice when a case is initiated in tribal court and when a case is initiated in state court. So to start with, it's important to understand the central theme here is that a case that involves an Indian child can potentially involve two separate governments. You can have one of those being a state or a political subdivision of the state, and obviously offices and agencies within that subdivision, like a county child welfare department within a county social services agency. Then you may also have an Indian tribe, and that tribe can have its own governmental structure, its own subdivision, such as a child welfare department or a social services department. We're going to talk primarily about child welfare cases today because that's where most of the activity and the litigation involving the Indian Child Welfare Act arises. But it is important to remember that Icwa also applies to other types of cases. Those include probate guardianships and voluntary adoptions. So even though we won't be talking about those much, if at all, during this webinar, please bear in mind that those cases are subject to the Icwa and to the jurisdictional discussion that we'll be having today as well. All right, so to begin with, jurisdiction. Black's Law Dictionary defines jurisdiction as a government's general power to exercise authority over all persons and things within its territory, or a court's power to decide a case or issue a decree. For our discussion, the best thing to do is to think of this as a blend of the two. If you want to condense it down into a simple phrase, power to act is one that I like. In the child welfare context, a state's power to act is generally limited to children within its borders. But an Indian tribe is not subject to that same limitation. A tribe has the power to act in any case involving one of its children. It does not have to be on that tribe's reservation. In fact, it does not even have to be in the same state that the tribe is located. We'll talk more about that later, but that's why we want to combine the two definitions of jurisdiction so that we don't just limit ourselves to things within a government's territory, but we're also talking more broadly about just the power to act. And then, following from that definition, concurrent jurisdiction, which again Black's Law Dictionary defines as jurisdiction exercised simultaneously by more than one court over the same subject matter and within the same territory, or jurisdiction shared by two or more states. And again here we'll be talking about some combination of those two ideas. A child welfare case does not need to be within the tribe's territory for the tribe to have the power to act. And it's also important to know that not all tribes have formal courts, but that does not diminish their power to act. So when we talk about tribal courts in today's discussion, we're not necessarily talking about a judge sitting above everyone else in the courtroom with a black robe. We'll talk about the specific definition a little bit later on of what under the Indian Child Welfare Act constitutes a tribal court. But for now, just remember that you don't necessarily need a formal court. So again, going back a slide, we're blending these two concepts so that we're not just looking at a territory that's shared by a tribe and a state, but we're talking about those two governments interacting, and for a tribe that can be outside of its own territory. All right, So a little bit of background on the Indian Child Welfare Act. There are numerous publications that will go into much greater detail about it. We have several of those on our website, but they're easily found across the internet if you want to learn more about Icwa. For our purposes today, one of the things that's important to know is that it was passed in response to the removal of high numbers of Indian children and those children's subsequent placement in non-Indian homes. It's codified in federal law at 25 U.S.C. 1901 and the following sections. That is Title 25 of the U.S. Code, Section 1901, and then the sections that come after that. And one of the things that we're going to focus on today is that it gave tribes certain rights in cases involving tribal children, and those include jurisdictional rights. The Supreme Court has said that those jurisdictional rights are at the very heart of the Icwa, so it's a very important part of the legislation. One thing to remember when you're talking about whether a case is involving the Icwa or not is if the child involved is an Indian child, and that's defined at 25 U.S.C. 1903 subsection 4. That definition is any unmarried person who is under age 18 and is either A, a member of an Indian tribe, or B, eligible for membership in a tribe and is the biological child of a member of a tribe. So if you have either one of those present, then you have an Indian child, and the Indian Child Welfare Act will apply to that case. All right, turning to Public Law 280 for a little bit of background. And as with Icwa, there are a number of publications available on this. Public Law 280 is a very, very complicated law, and so we're going to be talking just about a limited portion of it today. It's a federal law. It was passed in 1953. One of the important things to know is that prior to its passage, the state had a very limited role in Indian country, in Indian lands. And the reason for that is because in the federal constitution, there's something called the Indian Commerce Clause. And the Supreme Court has held that that gives the government exclusive power over Indian tribes. The federal government exclusive power over Indian tribes. And so states historically had very little authority in Indian country prior to the passage of Public Law 280. In addition to that federal authority under the Constitution, Indian tribes have their own inherent jurisdiction over their members and their lands. And it's not essential for our conversation today, but it is interesting to note that this has been found to actually predate the Constitution. But for our purposes, what we should take away from this is that prior to Public Law 280, jurisdiction on Indian lands was primarily federal and tribal. Then what did Public Law 280 do? It granted criminal and limited civil jurisdiction to the state in what are called the mandatory states, and those are California, Minnesota, Nebraska, Wisconsin, Oregon, and Alaska. There were a number of other states who were given the option of assuming that sort of jurisdiction later, and a number of them did. You can find the complete list online if you're interested in which states adopted Public Law 280 or adopted it in parts of their territory. The interesting thing to know about these mandatory states is that the tribes in these states had absolutely no say in whether this change in jurisdiction occurred. This was something that was entirely forced upon them and has led to a number of unintended consequences as years have gone by. Those are, not surprisingly, outside of what we're going to be talking about today, but there is a great deal of literature on that as well. So the short version of what PL 280 did is that it created this new criminal and limited civil jurisdiction in the state governments. And as California is one of the mandatory states, it's been in effect here since 1953. All right, the jurisdictional provisions of the Icwa. There are 3 of these, and these all appear at 25 U.S.C. 1911. The first one is what we'll call exclusive tribal jurisdiction type 1. And what this is when a child custody proceeding involves an Indian child who resides or is domiciled within the reservation of a tribe, that tribe shall have exclusive jurisdiction, and that means exclusive as to the state. But notice this part in italics, except where such jurisdiction is otherwise vested in the state by existing federal law. And what that refers to is Public Law 280. And there's another portion in the Indian Child Welfare Act that also specifically refers to Public Law 280. So what this is saying is that in a Public Law 280 state, even if a child resides or is domiciled on the reservation, the tribe does not have exclusive jurisdiction. If, however, you're in one of those states where Public Law 280 does not apply, then a child who is residing or domiciled on the reservation is subject to the tribe's exclusive jurisdiction. So that the state's child welfare services do not have jurisdiction over that child. All right, the second type of exclusive tribal jurisdiction. This is where an Indian child is a ward of a tribal court. And if you'll notice in this clause, there's no language referring to Public Law 280. It just simply says the tribe shall have exclusive jurisdiction, notwithstanding the residence or domicile of the child. So in other words, we don't care if the child lives in a Public Law 280 state. We don't care if the child does not live in a Public Law 280 state. We don't care if the child lives on the reservation or off the reservation. If the child is a ward of the tribal court, then the tribal court has exclusive jurisdiction over that child. And the best way to think about wardship is if the tribal court has some sort of continuing authority or oversight over that child. I think most often when you'll see this is when the tribe itself has opened a child welfare case or has determined that the child is otherwise in need of care. Maybe there's been a guardianship in tribal court, or the tribal court has designated someone as that child's Indian custodian. And the tribal court has some ongoing case or some open case for that child, and in that situation the child can be termed a ward of the tribal court. And in that case, it's really just the state finding that out and then transferring the case back to the tribe. And we'll talk about the mechanics of that or some of the specifics of that a little bit later today. Okay, so we've got the first type here of exclusive jurisdiction, and that's at 25 U.S. Code 1911, subsection A, the first part of that subsection. And we've got the second type of exclusive tribal jurisdiction, and at 25 U.S.C. 1911, still subsection A, but at part 2 of that subsection. Now we move on to a different subsection. And here we're no longer talking about exclusive jurisdiction. Instead, we're talking about what's been called transfer jurisdiction or referral jurisdiction. And this is at 25 U.S.C. 1911, subsection B. And what this says is that in any state court proceeding, the court, in the absence of good cause to the contrary, shall transfer such proceeding to the jurisdiction of the tribe. And we will talk about some exceptions to this transfer later today. We'll talk a little bit about the impact of a transfer to tribal court. But the short version of this is that the tribe has the jurisdiction to transfer the case into tribal court or whatever tribal forum the tribe has determined is appropriate, out of state court and into tribal court, unless there is an exception that applies. All right, so those are the three main jurisdictional provisions of the Icwa. Now, there's a great deal more involved in the law. Most of those things revolve around rights that the tribe has if it does not transfer the case into a tribal venue, but if it keeps the case in state court and proceeds as a party in those state court proceedings. So, moving on now to the jurisdictional provisions of Public Law 280. We talked a little bit about how Public Law 280 gave the state of California both criminal and limited civil jurisdiction. And what we care about for today's conversation is that civil jurisdiction. The criminal jurisdiction Some people might think that it is relevant in a child welfare case, but it's actually not a criminal situation. It's not a case where the criminal provisions of Public Law 280 come in. And that's because in a child welfare case, the focus is not on prosecuting the parents. Typically, there are not any criminal proceedings involved against the parents. The focus is on trying to reunite the family if possible, providing services to the parents and to the children. And if for some reason reunification can't happen, then finding a safe home for that child to grow up in. So we're going to ignore the criminal side of Public Law 280 today, and we're just going to talk about the civil side. And that civil jurisdiction is codified at Title 28 of the U.S. Code, Section 1360. Now, we don't really care all that much about what Section 1360 actually says. And the reason that we don't is because there's been several very important Supreme Court and Ninth Circuit cases that have interpreted it for us, so that we now know with respect to child welfare what Public Law 280 says, even though Public Law 280 itself doesn't clearly say it. So if you are curious about the text of Public Law 280 itself, about the civil jurisdiction section, you can go to 28 U.S.C. 1360 and take a look at it. But what we're going to be focusing on today is the meaning that the Supreme Court and the Ninth Circuit have attached to it with respect to child welfare. All right, this is one of the things that the Supreme Court says, and I think that this really gets at the heart of what civil jurisdiction under Public Law 280 was intended to encompass. What the Supreme Court has said is that Congress never intended civil laws, as that term is used in PL 280, to mean the entire array of state non-criminal laws, but rather Congress intended civil laws to mean those laws which have to do with private rights and status. And I'd like to emphasize, if possible, extra emphasis on private, because that's really, at least according to the Supreme Court, what the thrust of Public Law 280 civil jurisdiction was. Giving private citizens a venue in which to pursue causes of action against each other. And the reasons for this are complicated. It goes back to what the general authority in Indian country was before Public Law 280. If you'll remember, it was largely federal and tribal. And then there are other limitations on tribal jurisdiction that essentially meant people who maybe had causes of action arise in Indian country would have a hard time, or possibly even no way of bringing those cases and seeking justice. So to continue with what the Supreme Court said, it said that civil laws of general application to private persons or private property would include the laws of contract, tort, marriage, divorce, insanity, descent, etc., but would not include laws declaring or implementing the state's sovereign powers, such as the power to tax, grant franchises, etc. These are not within the fair meaning of private laws. That was a 1976 case, Bryan v. Itasca County. And the 426 U.S. 373 line that you see there is its citation. That's where it's listed in the books of the reporters who write out these Supreme Court cases and publish them. So if you're interested in looking at the full case, you can punch that citation in and you can find it easily. Okay, so to summarize what that means, like I said, it was essentially Congress intending that state courts could hear private civil disputes that involved Indians. Now, it didn't have to involve only Indians. It could be an Indian person and a non-Indian person. It could be two Indian people. If it was two non-Indians, then generally state courts always did have the power to hear those cases. So the idea was Congress wanted to provide another venue for these kinds of private civil disputes. And this has come to be known as what's called civil adjudicatory jurisdiction. And the easiest way to understand why it's called that is that the state is being empowered to adjudicate, to judge, to decide a civil matter between private individuals. If you have read anything about Public Law 280, or if you are going to read about it, then you will read a tremendous amount about what's called civil regulatory jurisdiction. And if you compare civil adjudicatory jurisdiction to civil regulatory jurisdiction, the primary difference is that civil regulatory jurisdiction is much more the state acting as a government. It's the state saying, these laws, these rules, these regulations shall apply in Indian country. And that might be taxation, that might be trying to regulate land use, that might be trying to regulate environmental cases, clean air, clean water. Now remember, those are subject to federal law. We don't need to talk about those today, but when it comes to the state, that kind of exercise of authority is something that the Supreme Court has said was not conferred by Public Law 280. So yes to these private causes of action, yes to being able to hear private disputes between individuals, no to these larger state as a government type situations where the state would be trying to regulate activity or regulate land, regulate large parts of life on Indian land. All right, so with that difference in mind, if we are looking at a child welfare case, then we have to ask ourselves, in removing a child from its parents and placing it in foster care, and requiring the parents to complete a case plan to demonstrate parental fitness, surely the state is acting in its role as a government, right? Meaning that would be civil regulatory and therefore outside the state's jurisdiction on Indian lands. If you think about it, there's actually a very good practical argument for this, because the state is, relying on its authority, its powers as a state to do these things. However, the Ninth Circuit has said no. The Ninth Circuit has looked at this in a great deal of detail, and if you look at the bottom of this page, the case that they did this in was a 2005 case called Doe v. Mann. The citation is the same code there for finding where it's published if you want to read it in full. But the Ninth Circuit looked at the Icwa, and it noted that Icwa specifically references Public Law 280 in a couple places. And it also analyzed child welfare cases, and it decided that they were more like the adjudication of a private individual's status, as opposed to trying to regulate large swaths of on-reservation activity. Said, well, you're really trying to determine what are the private rights of these parents? What are the private rights of the child? Do the parents get their child back? Does the child have a right to a different home, a safe home, a stable home? And so because the focus on child welfare cases, the Ninth Circuit says, is more of a private consideration than a larger, broader, more public consideration, the Ninth Circuit decided that California's child welfare law is actually civil adjudicatory, and therefore that cases that the state brings in state court, and this includes cases that originated on Indian land, that those are within the state's jurisdiction under Public Law 280. So what all this means is that if you put the Indian Child Welfare Act and Public Law 280 together, you have a situation where both tribes and counties have valid jurisdiction to initiate a case in their court system involving an Indian child, and it doesn't matter if that child lives on the reservation or off the reservation. Either one of those entities can initiate a case in their court system, and their jurisdiction will be valid. Now, what we'll talk about next is what happens if a case is begun in either one of those. In tribal court, you are almost entirely going to be operating under tribal law. The Indian Child Welfare Act does not apply in tribal court. It applies only in state court proceedings. There are a couple of federal laws that apply. Those are largely centered on background checks of foster homes, but those are not things that we're going to be discussing today. So for our purposes, what we really need to understand is that once a case goes to tribal court, the tribe controls what happens to it. There's no way for the county to try and transfer a case out of tribal court to state court. I mean, conceivably, the tribe could close a case, and someday, if the child was in danger again, the county could open a new case. And the only question at that point would really be, was the child a ward of the tribal court somehow, like we talked about earlier? But if you're talking about trying to move an active case out of tribal court, there's no way to move it out of tribal court and into state court. And finally, there's also funding considerations that go along with it, because when a case goes into a tribe's jurisdiction, the federal and state foster care money that normally come with those cases do not follow. And so at that point, the tribe, who might have a 4E agreement of its own with either the federal or state government, or might have some other funding mechanism for those cases, the tribe would take over the funding for foster parents, providing services, counseling, medication, what have you. That all becomes tribal responsibility. So cases initiated in tribal court are pretty straightforward. If it starts in tribal court, it's going to stay there. Now, if we have cases initiated in state court, that's a much different situation. The first thing that we would want to look at, if we had a case involving an Indian child that was initiated in state court, is this possibly subject to a tribe's exclusive jurisdiction? And in spite of the fact that California is a public law 280 state, you still can have a case where the child is actually subject to the tribe's exclusive jurisdiction. Some of the ways that that might happen are bulleted here below. We're not talking about residents on a California reservation, and we've talked about why between Public Law 280 and the Icwa that's true. But the child could be a ward of a tribal court, and that could be a tribal court here in California or a tribe in another state. The child could also reside or be domiciled on a reservation in a non-Public Law 280 state. And I think everybody understands what reside means. What domiciled means is where the child's permanent home is. You may have a child who is in California visiting relatives and on vacation for a month or 2 months living here in the state, but it's not their permanent home. So even though they're temporarily residing here in California, it may be that they're actually domiciled in another state, and if that state is not a Public Law 280 state and they're domiciled on the reservation there, then that child's actually going to be subject to that tribe's exclusive jurisdiction, not to the jurisdiction of a California court. And finally, you could also have a child who is a member of a tribe in a Public Law 280 state who has successfully petitioned under the Indian Child Welfare Act to reassume exclusive jurisdiction. The section that talks about that in the Icwa is 25 U.S.C. 1918. We're not going to go into detail today on what that petition process actually looks like, but it's important to know that that is a possibility, that even tribes in Public Law 280 states, if they have successfully submitted one of these petitions, may have reassumed the jurisdiction that Public Law 280 granted to the state and made it entirely a tribal jurisdiction again. Okay, so these are the possible ways that you could have a case, even in California, in a Public Law 280 state, subject to a tribe's exclusive jurisdiction. Okay, one thing to say about all of those situations is that none of those preclude the state from acting in an emergency. The state still has something called emergency jurisdiction, and what that means is that the county can take the child out of wherever they are, whether that's on the reservation or off, whether they're a ward of the tribal court, any of those scenarios that we just ran through. A state can still legally remove a child if they're at immediate risk of harm. And there are some procedures laid out for what happens after that, but it's typically involving the county or the state court, asking, is this child an Indian child? Well, where do they live? Contacting that tribe, finding out if, they're subject to the tribe's exclusive jurisdiction or a ward of the court, or something like that. But none of those situations prevent the county from acting in an emergency if there is some risk to the child. All right. So if the case is not subject to a tribe's exclusive jurisdiction, then the state court maintains jurisdiction. And at that point, the other type of jurisdiction under the Indian Child Welfare Act that we talked about earlier potentially kicks in. And that is at 25 U.S.C. 1911b. That's what we were talking about under transfer jurisdiction, also called referral jurisdiction sometimes. And that's, in a nutshell, where either the tribe or perhaps the parent or the child seeks transfer to tribal court. And the state court actually is required to transfer the case unless a parent objects or unless good cause is found to deny the transfer. This is something that, again, the Supreme Court has said is kind of at the heart of the Icwa, this jurisdictional scheme where we presume that the tribe has jurisdiction. We presume that the tribe is going to make the best decisions for its children. And the people who would be opposing that, if they're going to oppose that, need to show the state court something that the state court can legitimately call good cause in order to deny that transfer. So here are some things to know about the request for transfer. We talked earlier about how the tribe is not required to have a formal court. The definition of tribal court under the Icwa is at 25 U.S.C. 1903 subsection 12. And in short, what it says is that any body that the tribe decides is going to have the authority to hear these kinds of cases is legitimately considered a tribal court. That might very well be a tribal court. A number of tribes in California and outside of California have formal courts, but that might also be the tribal council itself. It might be a child welfare committee. It might be the tribe social services department or some office or employee within that department. It's whoever the tribe is designated to make these kinds of decisions. That's who's going to be considered a tribal court, and who, if a tribe were seeking to exercise referral jurisdiction or transfer jurisdiction, who the tribe could seek to transfer that case to. Transfers to tribal jurisdiction are covered by the new Icwa regulations. These are new federal regulations that came out and took effect in 2016. The regulations that are specific to transfers are at Title 25 of the Code of Federal Regulations, 23.115 to 23.119. These regulations are new, and the transfer subject is also covered in California law and California rules of court. That is California Welfare and Institutions Code Section 305.5 and California Rule of Court 5.483. And it remains to be seen with some of these federal regulations exactly how they will interact with state laws and rules of court that were already on the books. In general, when a federal law or federal regulation is passed or published, it's going to supersede state laws that conflict with it. But the Icwa also has a provision that allows for higher standards of protection to be applied if those are set forth in state law. So in other words, the Icwa creates a sort of minimum set of protections, and if states wish to increase those protections in certain ways, they're able to do that. So I just want to let people know that if you're looking at these federal regulations and also the Welfare and Institutions Code and the rules of court, that's something to keep in mind if there is any kind of conflict between the federal regulations and these state laws and rules of court. All right, and then once you have a case that is transferred to tribal jurisdiction, say that nobody is able to show the court good cause for the transfer not to occur, then the court orders the transfer. And once that occurs, then the points that we discussed several slides ago are going to take effect. And again, that's what law applies. Well, it's primarily going to be tribal law. Once it's out of state court, there's no transferring it back into state court. And then the funding considerations that we talked about in terms of having those, well, unless the tribe has a Title 40 agreement with either the federal or state government, having those federal and state funding sources cutting off and having the tribe deciding how to make that funding happen and provide those services. And that is the end of this webinar. If you have any questions, or if you are an individual or a tribe seeking services, you are welcome to contact any of our CILS offices. We ask that you contact the office that actually serves the county that you are living in or working in. This slide shows where all of our offices are located and the counties that we serve, and it's also got the contact information for each office, both our regular phone numbers and our toll-free numbers. This information is also on our website, which is www.calindian.org. And if you have any questions, please let us know. Thank you very much for attending this webinar, and I hope you have a good day.